There are a number of different things. One of the alternative dispute resolution covers a number of different things that you can do. The most common in Texas, almost all cases are going to be required to go to mediation before a trial court is going to actually allow the case to go to trial. Now, that is not an absolute rule, but I would say that is the case in 95% of the cases. And that's what most people are familiar with. And mediation, a lot of people come in thinking they know what mediation is, and most of the time they don't. So mediation is a situation where it would be me and my client in one room, opposing counsel and his client in another room, and then you have a mediator. And I typically like to use former judges or other board certified family attorneys who then are going back and forth between the parties to attempt to facilitate the settlement. And so how do they do that? Well, they're going to come in and talk to us about what are the weak points in our case, what do we really want, and what are the strengths of our case. And they're going to go and do the same thing with the other side. So they're going to play some devil's advocate there and figure out what those strengths and weaknesses are. Hence the reason I like using former judges, because they have an additional aspect of or a different perspective, I should say, on these cases. And they can say, when I was on the bench, this is typically how I would treat this situation. And that is something that I think brings a whole different level of value to the process. Now, there are other things you can do. There's binding arbitration, which can be in front of a single arbitrator or a set of 3 arbitrators. And that's where basically you say, okay, you know what? We don't know exactly when we're going to get reached to go to trial. We're going to go into this arbitration system and we're going to arbitrate the case. So basically you can try it just like you would a trial, but you are controlling. That's when you have the most control over the situation. You can decide what rules of evidence are going to apply, what the rules of civil procedure are going to apply. Is it appealable or not? How formal or informal is it going to be? How long is it going to last? Now, what are the costs and benefits of doing that? Well, the benefit is you control when it's going to happen. The cost can be you're hiring someone to act as a judge, okay, or to be an arbitrator in that situation. So you're paying for that instead of, say, having someone in the 158th District Court of Denton County do it, where taxpayers are paying for that. But you control when it's going to happen, and you don't worry about, I'm going to get bumped from this particular trial setting. You've also got opportunities with private judging. You can hire somebody to do that. So there are a whole lot of different things that you can do. What is most common is mediation.